Hello everyone, and thank you very much for coming today. It's wonderful to see some familiar faces on the attendee list as some of the some new ones. I'm joined here at our Cambridge office at a suitably distanced way away. My colleague Lucinda, who is a partner and head of the firm's Will and Trust Disputes team. Lucinda has worked with many charities of all sizes throughout her career and has seen legacy disputes of pretty much all types. I'm pretty sure from hearing her experience over the course of the last few days preparing for this. We are also extremely pleased to have Teresa Hicks here with us today, who is the Director of Fundraising and Strategic Partnerships at the Raspberry Pi Foundation. Teresa will kindly be sharing some of her vast experience in the sector with us today. I'll be chairing this morning's session. I'm a senior associate in our firm's charities and not-for-profit team, and I'm based here in Cambridge. Our charities practice offers expertise across all aspects of charity regulation and operation, and we also assist charities with their, clients with their philanthropic aspirations, as well as on strategic and ESG investments. Next slide, please, Katie. Today, we are going to be focusing on fundraising, specifically charity law and regulation, as well as what we hope will be helpful pointers and experience. I'll spend the first 10 minutes talking about the Fundraising Regulator, and then we'll look at considerations and regulations around fundraising and individual donors. So arguably the dry bit, but I guess it's quite important. Teresa and I will then discuss corporate fundraising, where, as mentioned, Teresa will very kindly share her experience and insight with us, which should hopefully spice things up a bit after my initial section. Lucinda will then bring it home by talking to us about legacy fundraising and some key considerations should you ever find yourself in the position where your charity is being challenged because of a gift left in a will. What we hope you'll notice from today's session is first a theme that communication with donors is key in all areas, but also that charities should feel empowered to talk candidly with donors about what the donor themselves is looking to achieve and what the charity needs, both of whom, of course, will wish to create a lasting impact. Fundraisers such as Teresa are innovative. I certainly remember when I worked in-house, I was always so impressed by our fundraising team and remain impressed by clients with the creative and engaging fundraising ideas. Because of this, we will try and look beyond high-level considerations in areas which we consider to be the key fundraising methods, but time pressures and the sheer breadth of fundraising world means we simply cannot cover everything. The Fundraising Regulator itself notes that fundraising law is complex and can come from various sources. Please do therefore ask questions at the end or get in touch afterwards with more specific questions. Just a note of housekeeping that if you have technical issues, please raise these in the chat and of course questions in the questions and answers function. We'll also, just to note, we're not going to be going into data protection considerations or the tax side of things today, such as the treatment of various types of income or gift aid. But again, please do let us know if you have any questions. I think you all agree we could probably delegate a whole webinar on these things. So last in the introduction, we will be filming this webinar, and so it will be on our YouTube channel, which is probably the coolest thing I've ever said. And if you think friends or colleagues might be interested. So, given the extraordinary pressures that charities face over the last 18 months, maximising your fundraising efforts and harnessing the general public's generosity is important. So let's crack on with revisiting some fundraising principles. Next slide, please. Fundraising Regulator. I'm afraid we cannot speak about charity fundraising without briefly touching on the Fundraising Regulator, which celebrates its 5th anniversary this year. Fundraising Regulator is a non-statutory body whose role is to set and promote fundraising standards across all areas and investigate fundraising practices and complaints. Its website hosts guidance as well as, importantly, the Code of Fundraising Practice, which it took over from what was then the Institute of Fundraising. The code sets out the responsibilities that apply to fundraising carried out by charities over and other fundraising organisations in the UK. A lot of you may already be familiar with the code. It's relatively user-friendly, and the inception and the exception of a fundraising idea, I would generally recommend revisiting the code just to check off ideas against the required standards. As a non-statutory body, as the name suggests, the Fundraising Regulator has no statutory regulatory powers, unlike, for example, the Charity Commission. So as we say, it has no teeth with which to bite. Although there is a statutory requirement for those charities that must have their accounts audited to include a statement on their fundraising strategy, practices and standards in the annual reports. The Fundraising Regulator has entered into a memorandum of understanding with the Commission, setting out how they intend to work together, which includes the Fundraising Regulator having the capacity to report to charities to Commission if a matter they think warrants sufficient concern. A good example of this is continued non-compliance may indicate wider governance issues, and so in that situation, the Fundraising Regulator may think they need to refer the charities to the Commission. Lastly, the Fundraising Regulator manages the Fundraising Preference Service, and the Fundraising Regulator regards a failure by charities to comply with the stop request submitted via the FPS to be a breach of data protection law. The Fundraising Regulator and the Chartered Institute of Fundraising have published joint guidance about fundraising and COVID in consultation with Public Health England and the Health and Safety Executive, and so I do recommend you take a look at this on the Fundraising Regulator's website if you have not done so already. Next slide, please. So on to the good stuff. The charity law points to consider around fundraising from the public rather than pitching in with ideas on fundraising strategy, which is bespoke to each charity, of course, given your cause and the demographic of your donors. I will be touching on the sort of nub of legal points and pitfalls in what we tend to consider as the main fundraising categories. There is a lot to cover, and as you can tell, I will be cantering through. And so please excuse the ground I'm trying to cover, but in preparing for this webinar, of course, it all seemed relevant, and I hope what follows will act as a useful reminder of the types of individual donor fundraising. So first of all, some housekeeping, just a gentle reminder to have early conversations with donors about the importance of having unrestricted funding. As you will see, there are some pitfalls along the way with restricted funding, but please remember to agree and document the gift is unrestricted if you can secure it as such. Donors generally, in my experience, wish to be as helpful as possible, and certainly some may not even realise the implications of asking for funding to be applied to a particular area. Then a further overarching point, which is what charities need to say in fundraising materials, a less interesting type, but still highly important set of sort of communication. The key rule here is if a registered charity has a gross income in its last financial year of over £10,000, the fact that it is a registered charity must be stated in legible characters in all notices, advertisements and other documents issued by or on behalf of the charity that solicits the money. So this is also whether expressly or by implication. And so, however, there are rules that apply particularly if the charity is a company, and so do take time to consider the correct wording on fundraising materials. Also, if there is some literature which will also be used in Scotland, the rules are slightly different there, and so do check what applies there as well. Next are public collections. These come in various guises, and we are finding that a lot of charities are using online platforms to try and reach donors. And we will be touching on the use of social media in a further webinar later in the autumn. So please do watch this space. But it does depend on your demographic of your community and potential donors. And so house or public collections still do take place. You may wish to take advantage of post-lockdown novelties like posting collection bags of clothes, given that apparently some people have had some time to sort through their houses this last year and a half, or fundraising at local public places as streets begin to fill up again. There are generally speaking two types of public collections. These are collecting money or the property for charities through house-to-house visits, which are known, as you might expect, as house-to-house collections, and collecting money or selling articles for charity in streets or public places, street collections. And please note that these street collections are different from professional fundraisers, so chuggers, although I hate that word, which we will come on to. With house-to-house collections, this includes public houses, factories and other offices to collect or sell items on the basis that the proceeds will go to charity. which includes this collecting clothing, so sort of bags, post boxes. My reason for mentioning these is to remind you that normally a licence must be obtained from the relevant local authority or in Greater London, the Metropolitan Police. So please do bear this in mind in the early planning stages. Similarly with street collections, if you're holding a collection in the street, so using collection buckets, for example, and again, those are different from professional fundraisers, you'll need to obtain a licence either from a local authority or again, the Metropolitan Police. There are other types of public collections, including private ones. So if your collection is still open to the public, but it's being held on private property, a bit of a common sense point, but you will need to obtain permission from the landowner or manager. And do pay attention to these points. With my Charity Law Association hat on, I had a meeting the other week with the CEO of the Fundraising Regulator, Gerald Oppenheim, and he said that he had a fundraiser come to his door, and he did let them know who he was, and very fortunately, the fundraising person did do very well. But yes, the rules do apply, and please do remember to check in early doors with your obligations in this area. So moving on to professional fundraisers. It is common practice for charities to engage and pay fundraising agencies or other third-party service providers to act as their agent in raising funds for the public on their behalf. Teresa mentioned when she and I were catching up ahead of today that it's often a false economy to try and bring this type of fundraising in-house, and professional fundraisers generally do know what they're doing. It's just the key is early communication with the agency about your expectations, as well as the professional fundraisers' onward communication with the public, which is probably the biggest risk factor. A common example of a professional fundraiser is this sort of chugger person, where they engage a fundraising, where you would engage a fundraising agency to recruit donors by stopping them in the street. Provisions in charity legislation, together with supporting regulations, place restrictions on those professional fundraisers, which includes the need for them to make solicitation statements. There's no statutory prescribed wording, so no official script, but these fundraisers must state the name of the charity or charities they're fundraising for, as well as how they will be remunerated for their work in securing donations. And the aim here is to secure transparency for the public. You must also have written agreements in place which cover off certain requirements, including how the charity can audit the agency's records, how to terminate the agreement early, and particularly how the charity will benefit from the arrangement, and of course how the fundraiser will be remunerated. Early conversations, particularly about remuneration, helps avoid ugly surprises when the charity has already committed a lot of time and energy to developing a relationship with an agency. You know, just this week I've had someone say they were surprised by the fees that they were being charged, and they were already too far down the road to turn back. So yes, early communication again. Next slide, please. Lotteries and prize competitions. Like a lot of areas of fundraising, the regulation in this area is disconnected from the types of fundraising, as well as generally in specific area itself, with various pieces of law sort of applying from each area. So I just want to mention headline points that lotteries are generally illegal unless they fall into one of the categories permitted by law. Aside from the National Lottery, there are 8 types of lottery. The main ones we tend to see charities using are small and large society lotteries, both of which require a licence either from the Gambling Commission or registration with the local authority. These are generally defined by the level of ticket sales being either side of £20,000. So just check in on that early, because you don't know how long it will take to get your licence. I'm not going to go into more detail because sort of gambling law is again another session on its own, but the Fundraising Regulator did publish a blog yesterday about lotteries, so there is help out there, and they do also have a section on their website for lotteries. Lotteries are distinguished from prize draws. A prize draw is basically a competition. A competition is not a lottery if it satisfies the skill test. So I spot the difference, for example, or requires no payment. So a free draw competitions which generally depend on skill or judgment or knowledge can continue to operate outside gambling legislation. Lastly, I just really want to talk about failed fundraising appeals. Failed here is a legal term meaning that the funds cannot be applied for the reason they were gifted. Charities often undertake appeals to raise funds for specific purposes, the classic example being to fund repairs for a church roof, for example. As it's difficult to predict how much money will be needed for a particular purpose, which disaster relief appeals demonstrate really well. It is even harder to estimate, sometimes how much will also be raised. So it's not uncommon for an appeal or for a specific charitable purpose to raise either insufficient funds, so the purpose cannot be achieved with what you've raised, or more funds are necessary for the purpose, leaving a surplus. And so unless the fundraising literature, so again that communication point, expressly states how funds were to be used in these circumstances, the appeal is treated as having failed in whole or part because all or some of the funds cannot be applied for that purpose. In the circumstances, there are a few approaches to rectify the position, but they are currently admin heavy, including either trying to return funds to donors, advertising that the appeal failed so that unidentified donors can come forward, or applying to the Charity Commission for permission to apply the funds for purposes similar to the reason that they were raised. So the right course of action depends on where the funds came from originally and whether there's too little or too much. But ultimately the point I am trying to make is the result is time and money which could be avoided from the right terms and conditions at the outset. So basically something along the lines of the funds can be applied to a general pot if necessary. And if you're anything like me and read the small print on posters, you may notice these sort of things on appeal posters in trains, for example, where they say, please give to this cause, but we can apply it to the general pot if needs. So to avoid the difficulties of failed appeals, charities should therefore take care to ensure that fundraising literature is phrased in such a way to allow funds to be applied to the general pot if insufficient or too many funds are raised. Lastly, I'm not going to touch on refusing and returning donations because this consideration, at least to me, seems to transcend the different types of donor, but perhaps if there's time at the end, this is something we can focus on. So thank you very much for your attention there. Could we have the next slide, please? I'd now like to introduce Teresa Hicks, who has very kindly agreed to be interviewed about corporate fundraising. Teresa is first.
Could I just say, I think we need another slide, Katie. We've got the individual donors slide up. It's a different slide. I think we need the next one, please.
Sorry.
Next slide, please, Katie. Thanks.
Sorry about that. Teresa,
morning.
Would you like to introduce us to the Raspberry Pi Foundation?
Yeah, sure. Thanks, Kate. So I really want to just bring to life a little bit about the Raspberry Pi Foundation. Hopefully it'll also just help to add some context to some of my answers. I just want you to think about, technology is everywhere. So it's everything we do at work, our social lives, we consume our news through that, through technology, even down to your household shopping. We use technology for everything that we do. Now, the problem the Raspberry Pi Foundation is trying to resolve is that there are millions of young people around the world who don't have access to technology, but not just that, they don't know how to use it. And that's not just impacting their lives now, it's going to impact their future. So our mission at the Raspberry Pi Foundation is to put the power of computing and digital making into the hands of young people. And what do I mean by this is that we want to make sure that young people have the equipment and they have free, easy access, engaging, and I think really importantly, fun opportunities to work with technology and digital making. And some of the ways we do this is through engaging with teachers to make sure they know what they're teaching to the young people. Clubs, we offer clubs like networks of clubs for young people to learn coding. Which is a really key part of digital making. And we do really cool stuff. So one of our projects we have is called AstroPi, whereby we have young people coding computers, sending them to space, to the International Space Station, and we've got astronauts actually using their equipment to complete experiments in space. I mean, I don't know about you, but that totally blows my mind. But that's the world that young people should be growing up in, and their future will be evolving around kind of work like this. So they're just a few examples of the work we do, but it's amazing the stuff that young people can do now, but so many people don't have access to it.
Fab. Thank you very much for that. So as part of that, you know very well what it's like to engage with corporate partners, I'm guessing. And so it would be very useful if you could just sort of explain how you approach working with corporate partners for everyone listening.
Yeah, sure. So, I mean, I've been working in the corporate partner market now, I think must be for about 18 years. That blows my mind as well, just thinking it's that long. I don't know if I should have revealed that. And the biggest thing I have learned around approaching and working with partners is understanding what's really important to them. So gone are the days where you just go and go, do you want to do this? Actually, it's about working in true partnership. So I would always approach a partner or a prospect partner by first of all doing my initial research, and the kind of the call out I'd say here is don't fall into the research hole of doing days and weeks of research. I'm talking about 30 minutes of research to understand who they are, but then go and talk to them. Now, obviously, we all love to meet people in person. We haven't done that for a while, but you know, a conversation with somebody is so valuable. Understanding from them, you know, what's important to them, who they are, how their company works, what do they want to get from working with a charity, who have they worked with before, and what's worked and maybe not worked so well, and what's their ambition around kind of income they want to raise. And the one piece of information I'd give about these fact finds is go in and listen, don't make an ask. And because coming away makes it so much more valuable to then think about truly, what do you have in terms of a organisation that meets their objectives? And I think it's really important that you try to match, so you have a true partnership as opposed to just throwing everything at them and hoping that something sticks. Another call out I want to make here is sometimes after these fact find conversations, you discover that actually the brand of the corporate isn't right to work with. And you know what, that's okay. It's actually okay to say, I don't think actually we're probably the right fit to work together. And it really adds value to your brand. And I know as a fundraiser, it breaks your heart every time you turn money away, but it's absolutely vital in terms of your future partnership portfolio that you would have. And the other thing I would say is sometimes partners feel really strongly about what they want to do. So for example, if a partner wanted to work with you on a kind of a commercial opportunity, but again, it wasn't right for you, or it doesn't deliver any value for you, it's okay to say no. Again, feels really strange, but it's absolutely the right thing to do. So just going back in terms of you've done this fact find and how do you match your opportunities? And I always talk to the teams I work with around this kind of idea of I have a cupboard of opportunities that the organisation can offer to partners, and in there it's everything we can do and everything that we could, and all the kind of what it's going to achieve for the partner. And having listened to them at the fact find, I go into my cupboard, my virtual cupboard, and think about those opportunities and take them out to the partner. Now, sometimes, and actually a lot of the time, you're probably not going to get it right first time, but you have absolutely shown you've got it right, that you've been listening to them, sorry. And it's about listening to their feedback and working with them to get the right opportunity there. And by doing that, you will absolutely build a really strong start to your partnership that's right for you and for them. And I can't emphasize that more.
Perfect. Inside, like sort of aside from the written agreements, so any sort of paperwork or process plans, is there anything that you would tend to put in place that supports a sort of a clear partnership properly?
Yeah, sure. So one thing I think is really important is advising your partners they have a dedicated account manager. Now, you know, I've worked in the huge organizations and smaller organizations, and for smaller organizations that sounds crazy, but actually what you're really saying is you've got one person that you can make contact with about anything, and that person's role is then to engage with the right people across the organization to help answer their question. And I think having that one person that's a dedicated point of contact is really, really important. Another thing that I have kind of recognized works really well outside of the agreement is creating something I would call a ways of working document. Now, this is not a legal document, but it's a really clear kind of plan of your expectations essentially together, not just yours, but theirs as well. So everything from what do you want to get from this partnership, how much do you hope to raise, how to use brand guidelines when they're going to pay their money and how they're going to pay their money. And then it just can evolve over the partnership with you. So everybody's really clear around what's expected. And then just some other tools I found useful, I thought would be good to mention, is making sure that if there is for example, a Charity of the Year partnership, actually having a calendar of opportunities that will work for both you and the partner. Any templates that might be useful, like press releases or social media kind of content that might be useful, share it at the start. And also just really thinking, what does that partner, this sounds really obvious, but what does that partner need to deliver what you've kind of set up? So do you know what, if it's to do with I don't know, having materials or t-shirts for something they're doing, or I don't know, collection tins, make sure they've got it from the off. Don't wait for them to come to you, because it's about giving them that experience. And that's really important from day one of setting up the partnership.
Really good advice. Sort of running out of time, which I feel like is the theme of this webinar, but have you got any lasting advice? One thing you wish in your, start of your career, someone said, do this.
So I put so much value on making sure that you have a really effective, what I would call a stewardship plan with a partner. So with any partnership, the way you want to make them feel is they have such a great experience working with you that they never want to leave. And you know what, if they do leave you, if they go somewhere else, they realise how great the experience was and comes back. I always think about it like the John Lewis effect. Once you shop from John Lewis, it's really hard to shop anywhere else again. And the stewardship plan and putting the value into how to create interactions, meaningful interactions that are important to them at the right time is really important. And I would consider everything from what your organisation has to offer, whether it be events or access to senior people, right through to setting up Google alerts about their business, so that when there's big news breaking about some great new initiative they're running, you can contact your point of contact and say, wow, this sounds amazing. And again, it's about how you make them feel. And if they feel connected to you and they feel connected to the organisation, your income will grow. And my last kind of caveat I would add is, when you're planning your stewardship plan, don't just focus on the in-year income. Think about what that long-term income potential could be with that partner and over how many years it could last. And what stewardship plan do you need to put in place to keep them engaged over that period of time? Because if you're thinking about just the in-the-moment picture now, you'll never release the potential from that partner.
I think this sort of stewardship point is something that we should hopefully pick up a bit later down the line. But I'm afraid we have to turn back to another canter through law. And I'd like to introduce my colleague, Lucy, who's sat across the way from me. And Lucy will be taking us through some legacy fundraising points. Legacy fundraising over the next decade is due to increase by, I think, 46 billion, I think I was reading in Third Sector yesterday. So yes, over to you, Lucy.
Thanks, Kate. Yes, legacies and wills. I think despite the challenges that the pandemic has posed in recent times, legacies in wills will continue to remain a fundraising cornerstone for charities. Legacy Foresight, I think, reported that fundraising income fell by around 11% in 2020, but it's remarkable, I think, how the sector has adapted and recovered since then. The pandemic has caused charities to get, I think, better and better at legacy promotion, and some are now doing some really innovative stuff to make sure that legacies remain a central income stream. So there's a huge amount of work going on, and that work is extremely important. Legacy fundraising a key cornerstone, as we said, but unfortunately, one of the threats, I think, possibly to undoing that good work is claims against the estate of the donor who has left a legacy to charity. And these are fairly common. I've seen a fair few over the years, having practiced in this area for now, I think, 18 years, alongside Teresa's 18 years. So it's a sad fact that claims always pose cost risks for charities that need to be carefully managed. I think the average size of a legacy left in a will is between £3,000 and £30,000. So a careful balance has to be struck always between a charity trustee's duty to preserve the assets intended for the charity, but also the legal and moreover the time costs of taking steps to defend a claim. Over the years, I've seen several cases where legacies left to charities and wills have been threatened by claims against estates, whether that be an adult child claiming that they were unfairly excluded from a will and that the will fails to make reasonable financial provision for them, or where there's a dispute as to the interpretation of the terms of a will, or where an application is made which asserts that the last will is invalid. And that's an either-or. An all or nothing situation. So either the will is valid or it's not, and the legacy might fall away entirely. And I think, having seen a fair few of these, it's often the case that you think, oh, many of these claims really could have been easily avoided. And I just thought it'd be helpful for me to run through a few points that I thought would be helpful to look at in terms of what can be done to avoid claims arising against these very valuable legacies. And what we can do to try to mitigate the possibility of claims arising in the first place, because they are, as I say, very time consuming to deal with. I think the first point, and I would say this, wouldn't I, because you must always consult a solicitor, but I think it's imperative to ensure that the legacy is expressed in clear and unequivocal terms. You might think, well, that's surely easily achieved, but sadly not. Claims relating to the interpretation of wills are, fairly common. Just to talk about a recent case, for example, by way of example, there was a donor who left a gift of a house to a charity, with the rest of her estate falling into residue to be divided between 3 other charities in equal shares. She lost capacity, so she drew up her will, say, 20 years ago, specific gift of the house to charity. She lost capacity and moved into a care home permanently, and her house was sold to fund care costs. So the gift to our client charity of the house, which was worth over £1 million, would fail on her death because the donor obviously no longer owned the property. So her attorneys made an application for a statutory will, which you can make when somebody lacks capacity. You can apply to the Court of Protection to say, rather than this will, we think we would like a will in these terms, please, which would more accurately reflect what she intended to do. And the attorneys, though, their starting position was that the cash representing the proceeds of sale should just be shared equally between our client and the other 3 charities who were to benefit under residue. Now, we said something about this because we obviously evaluated it carefully, but our client charity in that case was able to show that the donor had a very close association with our client. It was a London hospital who had cared for her late husband and had provided him with groundbreaking treatment over a period of years, and it had kept him alive for several years longer than would otherwise have been the case. So we were therefore able to make a case for our client charity to be treated more favourably than the other 3 charities under the terms of the statutory will, as it was clear that the donor, had she retained capacity, would have wanted the cash proceeds representing the proceeds of sale of the house to go to our client alone and not for them to fall into residue. And this is just a simple case of, had the draftsman included the words the property or the cash representing the proceeds of sale, the issue wouldn't have arisen and the gift would probably have been saved in its entirety. So we were able to obtain an order in that case for our client charity's costs to be paid from the donor's resources, which is the standard order where the donor has lost capacity. And the application itself was considered to be in her best interest because this is what she would have wanted to seen happen. So we could save the situation in this case, but it's not always the case that you can. And as I say, just for the sake of a few words having been missed out, that was a real shame. Other common issues in drafting relate to how the charity is named in the will. Again, it might sound very basic, but the drafting of the will should cater for a change in your charity's name or a merger of your charity. Ensure that only not just the charity name is included in the will, but also the charity number and its registered office address, so that it can be clearly identified and there's no dispute or ambiguity as to what was intended. Because obviously it's possible your charity may cease to exist in its current form after the donor has died. And if there's any difficulty in identifying it on death, it can give rise to disputes and increased costs for the charity. You're potentially looking at rectification claims or something along those lines to sort it out otherwise. A theme that I think Teresa and Kate have already touched on, which I would say is hugely important, is so far as possible, do try to see the communication with potential donors as a sort of a lifelong endeavour and talk to the donor about their intentions whilst they're alive, documenting their wishes as well where you can. I think it's certainly the case that where these claims arise on death, if a charity is able to demonstrate this close association or even an association with the donor, there is a better prospect generally of the charity being able to secure the legacy intended for it. Even when you have a needy adult child that is claiming under the 1975 Act, for example, there was recent guidance from the Supreme Court, no less, in 2017, that a court's not going to lightly disturb a testator's wishes in relation to their chosen beneficiaries, and that applies even where the chosen beneficiaries are charities. It's often thought that charities, don't have a good defence to these claims. Well, that's actually not correct. Some larger charities are not likely to be able to demonstrate a needs-based defence. So by that I mean most larger charities aren't able to demonstrate a need for provision from the estate, but that does not mean to say by any stretch of the imagination that they don't have a defence to the claim, and that will even be more so the case where they can demonstrate this close relationship with the donor. As I say, the case I mentioned earlier about the donors association with the hospital is a case in point. I think linking in with donors and supporters at key times in their lives. So for example, when they get married, if they move house, have children, these are all times at which a donor should be considering updating their will. And they're good times to link in with them and discuss potential gifts and having confidence in the work that you do and the reasons why, they might consider legacies. I think also, although you as charity trustees or those advising charities won't be able to talk to the donor's family yourselves, I think encouraging the donor to talk to their family about the intended gift is a really important thing to try to do if at all possible. I think one of the biggest catalysts of litigation arising post-death is surprise, the element of surprise, and getting intentions out in the open during the lifetime is certainly far preferable to families discovering what can usually be fairly significant bequests to charity. And if the surprise element is taken away because the family have had an opportunity to discuss the donor's intentions with the donor during the lifetime, then they've got time to come to terms with the decision and perhaps explore it with the donor in the lifetime rather than feeling in the dark. And hurt is usually quite a lot of the emotion that is abounding post-death. What other points do I want to mention? Yes, don't be tempted. I'm sure this is teaching people to suck eggs, but don't be tempted, please, to get involved in the will drafting yourselves. It can be, some charities I know signpost donors to certain free will services or online services. The risk with those is that, frankly, a not very thorough job will be done, and that the file post-death, so my job is largely poring over files post-death to see what the donor's intentions were and how those intentions came about. You're not usually going to get that sort of comprehensive attendance note taking service from online will providers. So, I appreciate you want it to be, sometimes, it's sort of a one-off legacy, it's a quick transaction. I think there are risks with doing it quickly, doing it cheaply, and you must ensure donors take proper legal advice, because there are other, intentions that come into it from a donor's perspective. Some are motivated by the wish to mitigate inheritance tax by gifts to charities, and those rules need to be explained to the donors so they properly understand, and there's no ambiguity again in the instructions or the drafting. And so take legal advice and encourage donors to take legal advice. Letters of wishes I would mention as being helpful. You will no doubt be aware that letters of wishes, by which I mean a document placed alongside a will that sets out the reasons why certain bequests are being made or how a trustee should apply the fund. They aren't binding on the trustees, but they are excellent evidence of a donor's wishes, which again can be very useful if a dispute should arise. Could I have the next slide, please? If, sadly, you've done all of these things and claims do arise, then I think it's definitely fair to say there are special considerations for charitable trustees to bear in mind when faced with a dispute. Litigation obviously can generate negative publicity, sadly, and it can damage a charity's reputation and put its future legacy income at risk if prospective donors are put off. I think the Charity Commission guidance has shifted in recent times as to the approach that charity trustees should take to claims. The guidance that was produced in 2010 was phrased in these terms. It said, litigation can damage a charity's reputation, and this can impact upon its ability to further its purposes effectively if the beneficiaries lose confidence in its services or its ability to raise funds if donors are concerned that money will be spent on litigation. But since that sort of anti-litigation approach, if I could put it that way, I think there's definitely been a softening of the approach. An updated guidance was produced in 2016, which still holds good. And I think that perhaps reflected a concern that too much of an anti-litigation stance might put charity trustees under pressure to settle claims even where the claims are weak, which of course conflicts with the trustees' overriding duty to preserve assets for charity wherever possible. So I think what now is the correct guidance is that litigation is no longer viewed as a last resort, and the emphasis is now on what is in the charity's best interests. Usually that translates into only pursuing litigation where other methods of resolving the dispute have been explored, and the obvious key method is mediation. I'm a huge advocate of mediation. Most claims, in truth, can be settled at mediation and before the issue of court proceedings even needs to happen. So most of the cases I deal with happily resolve, I'd say sort of 90% resolve at mediation. Very rarely can it be justified to, taking things to trial is a really big and bold step given the costs incurred with that. And usually if you have sensible people, which most people are ultimately, they will see the benefits of an early mediation. And when I say early, I mean even following the exchange of a letter of claim and letter of response. There's really no reason why mediation can't be explored at that early stage. So the duties of the charitable trustees, if faced with the claim, are under the most recent guidance from the Charity Commission to consider the prospects of success or failure of the claim against the estate and ask the lawyer to make a prospects assessment of the claim. So if the claim is very weak, it is going to be in the charity's best interests and also part of the trustee's duty to take steps to defend it cost effectively. And again, these claims can be defended cost effectively. If you decide to elect to defend the claim, you aren't committing yourself to a trial. There are several stages along the way before that. And usually a defence might look like a sort of fairly short form witness statement, confirming the charity's association with the donor and the reasons why this gift should be upheld. The cost benefit analysis is something that really drives most of the work I do. Not much point spending hundreds of thousands of pounds litigating over £30,000 legacy, but it is largely a numbers game. If you focus on the numbers, you usually are able to focus on the cost benefit analysis and what is the right step to take, what is the cost budget for the work, and how far should that be restricted to maintain proportionality of costs. Costs can be streamlined, of course, by joining forces with other charities who are similarly affected, and also consider if Charity Commission consent is going to be needed to consent to the compromise. Generally, though, in contentious probate claims, which are the claims I largely deal with, charity trustees will have the ability to compromise the claims themselves without reference to the Charity Commission. I'm not talking about charity proceedings. The statutory, the cases that usually relate to charity proceedings are sort of conflicts relating to a use of charities' resources or applications to remove trustees. I'm talking about, will disputes and 75 Act claims. Charity trustees can take those decisions usually themselves. Obviously, where there's a huge amount of money at stake, which can be the case, it's usually sensible to seek to make the Charity Commission aware of the claim and the steps that the trustees are taking to resolve it. but having had sort of fair few of those sort of sizable claims, the Charity Commission has been content with notification and an explanation in broad terms as to why this compromise is considered to be in the charity's best interests. So just some pointers there from me as to what you might do if these awful things arise for you that threaten your legacies.
Thanks, Lucy. We have run out of time really, but if people are okay to stay on for 5 more minutes, I feel like, particularly because we've got Teresa here, it'd be a real shame to not tap into her expertise and experience in the sector. If there are questions, please do ask them. Ask them now. We will see if we can rattle through it. But to get us started, over the course of sort of our preparation for today, and a theme that I think runs through all charity fundraising and how all these sectors and issues that we've spoken about today sort of link together, it seems to me at least that there's a sort of a funnel for a donor, and whether that's their initial sort of monthly direct debit through to potentially they're in a position where their company can sign up to their organised, as a corporate funder, then through their whole life as a major donor potentially, and to leaving a legacy. And you very eloquently, Teresa, spoke about this sort of donor funnel and how do you get them, or ladder, or whatever you want to call it, how do you get them and create this relationship? And if there's any sort of tips in, say, 5 minutes or so that you could share with us, it would be great if you wouldn't mind.
Sure. So I think maybe a better way to explain it is a kind of donor journey. So
that sounds much nicer than a funnel.
It does sound nicer. So I think as a fundraiser, you need to think about when a donor joins you, they can join you at any point in their life, but then how do you take that one interaction and create them to become a long-term lifetime donor for you? So you might often think, for example, that somebody, you could even go as far back as, at university, they do some fundraising and they get a great experience from a charity. They then get their first job and they suddenly have some money to be able to donate. So they then either set up some payroll giving or they set up a direct debit. They might also nominate your charity to be a charity partner at that point. I'm making some assumptions here, but no families, so they've got some more free time perhaps, so they might sign up to do something like a London Marathon. So that's another interaction point for you. But then as time becomes more challenging, when they have a young family, they might look for other ways that they can engage with you. So actually something like a direct debit at that point and being able to grow it might be really beneficial for them.
Do you feel like it peaks and goes back up again?
Well, I think it's about what's right, understanding what's right for your donors at specific points in their journey. And the ultimate place you want somebody to get to is that they leave a legacy in their will. And if you almost think about every donor that comes on board, how can they grow their income potential to ultimately leave you a legacy, and what's the journey to get them there? That's something I think for organisations is a really great way, because actually once you've got an individual engaged with you, it's much easier to convert them through the journey than it is to bring in new audiences. And the last thing I would say as well is there's evidence that shows that a high proportion of individual donors do go on to leave legacies, but as an organisation, you have a responsibility to educate them in the right way. And I often think as fundraisers, we can get quite nervous about trying to offer new opportunities. But actually, I like to think, who are we to make decisions on their behalf? It's our role to understand what's important to them and offer them those opportunities. And it's okay for them to say no lots. And they will tell you when they don't want to be offered these things anymore. But actually, if we're not giving these opportunities to engage, you won't grow their potential. So I like to think that we should offer our audiences to make those decisions as opposed to us making them for them. And that never quite feels right when you're working as a relationship with them.
We've got a very interesting question that's come up here. What's the donor demographic at the Raspberry Pi Foundation? How are you trying to tap into, who have you identified as your donors?
So the Raspberry Pi Foundation, we historically have worked a lot with corporate donors, and we're currently looking at different ways to diversify our portfolio. And we recently did some really interesting kind of individual giving tests with with different audiences outside of corporates. And one of the things that we identified was that people who were close to our Raspberry Pi computer brand or equipment brand, which is our trading a trading part of the Raspberry Pi brand, and they donate their profits to the foundation. But the people who were close to that brand actually resonated with the work of the foundation, you know. And actually what we discovered is that we have got people who were maybe into computing when they were teenagers, who are now maybe working in the tech world, and maybe are in their kind of midlife age, maybe got a bit more disposable income, suddenly are going, oh my goodness, I can't imagine a world without having access to this stuff, or not even understanding what it can do, because that's everything I love in my world. And they are giving us that they're kind of our biggest donor pool, which is a really interesting insight for me, having worked across different sectors, because actually middle-aged men are really hard to talk to because they've, you know, typically they're the hardest group to win over, because that, you know, then maybe, and that's maybe a big statement to make, but you know, in my experience, they're really
that's your experience.
And so for us, it's like, wow, they're really engaged. So actually, there's probably potential to really grow their income potential to us, because they're potentially not engaged with many organisations.
We have possibly one last question, if that's all right. And again, it's for you, Teresa, sorry. Clearly they are lured out, but we've got an organisation here that are looking at a new tier-based corporate sponsorship concept for organisations that don't have any sort of specific links or abilities to take services from them. So they wondered if you had any pointers on making this a success, so sort of tier levelling as a source of funding. So I imagine that's quite inceptual.
I think the most important insight I can offer around tiered funding is making sure that what you're offering back to that partner is relevant to what they are giving you. So don't throw everything at your smallest donations. Really think about what is the value of organisations working with you, and based on that donation value, what access should they have to you, your time, your assets, your organisation. And I think quite often as a in the sector, we like to try and make everyone feel great about everything and every donation, but actually then how do you differentiate between a £1,000 donation and a, I don't know, £500,000 donation, and the benefits that somebody gets? So the biggest piece of advice I can offer is be really selective about what you're offering your lower donors and the time you're giving them, and make sure it's relative to your higher donors.
That's perfect. We have very much run over, and I'm sorry, because I feel like I could talk about this all day, which makes me feel like we should do some more. So if there are anyone out there who has a specific request, if there's something you'd like us to go on another webinar about, do let us know. Contact us all individually, or contact Teresa through us is probably a fairer thing to say. And yes, thank you for bearing with me as I try to wedge in every single bit of individual donors. And yes, we're particularly grateful to Teresa for sharing all her experience, but thank you very much. And yes, we will see you all again.
Thank you.
Thanks.